Greetings. I hope I'm audible.
Two times we were clearly visible and audible. Hi, I hope we're clearly visible and audible.
Hello.
Hi everyone. Do we have participants from Amity University here? Do we have participants from Maharashtra National Law University?
Yes.
All right, okay. Thank you. So we'll just wait for some minutes for the other team to join.
In the meantime, can I just ensure that I'm clearly audible and visible?
Yes, Myra, you are audible and visible. Thank you.
Thank you so much.
Hello. I hope I'm audible to everyone here.
Yes, Ishmael, you are audible and visible.
Thank you.
Hello, anybody from admin here?
Hi, Rodrigo. Yes.
Can you confirm the defendant today in this round is Middlesex University?
Um, no, I think you may be looking at a different round, Rodrigo. Today is Amity University against Maharashtra National Law University.
Okay, well, in the schedule I have it says Middlesex. That's why I was confused.
Oh, all right.
It's a schedule that was circulated on the 3rd of May, so I assume it's the latest one.
Sorry, when was it circulated with you?
On the 3rd of May.
All right, I think it has been updated since then. I will have someone from the DIFC team send you the revised.
Okay, thank you. So it's just to I'm asking this to confirm that the right skeleton for the defendant is Bangalore University Law College of Bangalore, correct? No, sorry, Maharashtra National University.
That's correct. Yes, Maharashtra
Okay,
National Law University.
Maharashtra. Okay, very well. Okay, fine then.
Hi, Varsha. Are you from Maharashtra National Law University?
Yes, that is correct.
Right, great. Are there others joining from your team?
Yes, there's one more joining from our team.
All right, sure.
May I suggest to the participants to include in their name also the university they represent. That will help the bench.
Sorry, we'll do so. Thank you. I'm really sorry. For some reason, we're not able to find the option to do so. If this from Webnyay platform was still able to help us. In the meantime, I'm posting the name as well as the site that we are representing today in the chat box for the registered users.
Do we have all participants on the call now? So, Rodrigo, we're just checking. I think there was supposed to be another judge joining alongside you, Mr. Khalid Hussain. We're just following up with him, and we'll wait for maybe a couple more
How about
minutes.
Rohit Bhattacharya?
I think they backed out last minute.
Okay.
So it was only you and Mr. Khalid. We're just checking up on Mr. Khalid now.
Okay.
All right. Do we have all the participants from Maharashtra National Law University now?
Yes, we do.
All right.
Okay, if this is possible for the participants, I suggest that in your name you add at the end, in brackets, the name of your university.
Hi, Rodrigo. Sorry to interrupt. I don't think that functionality is available. Would it be okay if we added the
Well, they just need to log in again. They need to log out and log in again.
All right. Would it be helpful, Rodrigo, if they added it on the chat? The defendant, for example, has put in all the names of the members.
Yeah, sure.
Yeah. All right. So may I please request Amity University to add the names of their members, similar to how Maharashtra National Law University is added on the chat? And then maybe we could begin this round.
Okay, so only one judge. So we'll start alone. Correct? That's what you're saying.
Sure. Yes, if
Edmund
that's
sir
fine.
here. Can I speak to someone from the admin?
Yes, yes, please.
So just want to know the applicant side. Are they're not able to join this, or the link which was provided, they are in another room, is it? How does it?
No, I believe everyone's on the same room here. We have participants from Amity University as well as Maharashtra National Law
Oh,
University.
you have? Okay. I can't, because maybe I can't see it. Do you see me?
We're on Teams
Oh, you're on Teams.
because it sent us to Teams.
I'm just going to repost the link on this chat here. So maybe they can join using the link.
Try joining through the web.
Did you join?
Can you see the link on the chat?
Yes. Because they're in Teams, I think, with the link which was sent.
No, that's a, I mean, that's the link for the halls, which will essentially, it's more for networking with other participants
All
and just.
right. Let me just send it to them.
All right, do we have all participants now? Do we have everyone from Amity University? Just checking once again.
Yes, we're here.
Great. And do we have all participants from Maharashtra National Law University? All right, great. Over to you guys.
Okay, so Mr. Siddhantio from Amity University, can I ask you please to write in the chat? I assume you're senior counsel. Is also junior counsel here?
Yes.
Okay. So there's Mr. Kumar and Mr. Shibu. Can I ask you to write as the defendant did your details in the chat? Okay. Okay, so good morning, everyone. As first couple of housekeeping matters, can I ask the parties if they have an agreement regarding the timetable of this hearing?
I'm sorry, I wasn't able to make out what you said.
Have the parties conferred regarding the timetable, regarding the allocation of time for the various round of submissions in this hearing?
Yes, Your Lordship. I'm the senior counsel, and me and my junior counsel have allotted 17 minutes to each other for our arguments and 10 minutes for rebuttals.
Okay, so 17 minutes for the main arguments, got it, okay. That would be for both claim and counterclaim.
Yes.
And rebuttal, okay, so how many minutes is that for rebuttal?
10.
10 minutes for rebuttal, and that will be rebuttal or shall rebuttal?
Yes, Your Lordship.
Together.
Yes.
But you have not divided you have not looked at the time between rebuttal and shall rebuttal, have you?
Five minutes each.
Five each, okay. Okay, so Mr. Kumar, you're the senior counsel?
Yes, Your Lordship.
Okay, so unless the defendant has anything to add, I will let you start, Mr. Kumar. The floor is yours.
Counsel seeks permission to approach the bench. Counsel seeks permission to address the bench as Your Lordship. Good day, Your Lordship. This is senior claimant appearing along with my junior claimant in the case of Artemis Asathia versus Solar Dream Incorporated. Before this honorable court, my counsel and I have allotted 17 minutes each for our arguments and 10 minutes for our rebuttals. Counsel seeks permission to proceed with a summary of facts.
Please.
Much obliged. The claimant filed the case in the court of first instance on the following grounds, the claim being Solar Dream's liability to Ms. Asathia in tort and in breach of contract. The defendant files a counterclaim, which is follows, Ms. Asathia's liability to Solar Dream for breach of contract. Proceeding with the facts that birth these contentions, Solar Dream Incorporated is a Canadian spaceflight company that provides spaceflights for high net worth tourists, operating 4 flights with 10 passengers, each since its inception 3 years ago. Solar Dream organizes 2 spaceflights retreats annually, offering curated centered and around specific themes. The Stars Aligned Yoga Retreat, planned for February 15, 2024, was formulated by CEO Mr. X Delta and promised a unique space yoga experience. Ms. Artemis Astrathia, a renowned YouTuber with 27.3 million subscribers, suffers from chronic headaches and believes she is drawing energy from celestial bodies to heal herself. She purchased a ticket for the Stars Aligned retreat, hoping to find relief for her headaches through low gravity meditation and yoga. Artemis purchased a ticket for the retreat on December 10, 2023, signing the spaceflight agreement mandating a medical evaluation. On the 1st of February 2024, 2 weeks before the flight, Artemis flew to Dubai from Montreal with a layover in New York. She then checked into the pre-departure accommodation provided by Solar Dream, the Dream House, wherein she was quarantined with the rest of the passengers for 2 weeks before the flight. Despite experiencing severe headaches during the pre-departure quarantine in February, Artemis did not disclose the conditions as it wasn't out of the norm for her, but merely something she had been going through for the past few years. The spaceflight commenced on the 15th of February 2024 amidst concerns about the Vulcan COVID-19 variant. Two tests were mandated to proceed with the flight, one being the lateral flow test and the other the PCR test. The lateral flow test was cursory, with Artemis passing the lateral flow test but awaiting the PCR test. Artemis waited to get back the results of the PCR test but was informed that due to the delay of the labs, the test would take more time than anticipated to come back. Solar Dream green-lighted the launch after consultation of a nurse on duty, and what she said was that the lateral flow test was sufficient statistically to rule out any serious risks that the passengers had COVID-19. But this was before receiving the PCR test, and due to meteorological conditions, all passengers were green lighted for the space flight. Later discovering Artemis's positive PCR test mid-flight, and all passengers proceeded to contract uh, COVID-19 during the retreat, leading to premature return back to Earth, worsening symptoms for Artemis. If there are no preliminary questions, Council seeks permission to proceed with the contentions.
Please.
Much obliged. Ground 1. Solar Dream is liable to Ms. Asathia in tort and breach of contract. For the sake of convenience, this argument has been divided into two legs, dealing with the tort and breach separately. Solar Dream breached his duty of care. Firstly, in pursuant of the USA jurisprudence in medical malpractice, determining if there has been a failure to comply with the informed consent requirement, the claimant must prove A. An operator/provider failed to disclose a material risk of the activity undertaken or reasonable alternatives. 2. The participant would have chosen against the activity had they been informed. 3. That as a result of the activity, participants suffered harm/injury. The material risks of spaceflight have been defined by neither law nor regulations, and even the spaceflight program has the opportunity to inquire about the hazards or the risks of the mission. These hazards are not known, rendering it impossible to obtain a spaceflight program agreement to allow to be made with full knowledge of the risks involved and alternatives. Artemis Asathia asserts that Solar Dream Incorporated had a duty of care towards safety and health during the spaceflight and associated activities. And as a commercial spaceflight operator, Solar Dream is held to high standards of safety, especially considering the inherent risks involved in space travel. Bringing Chapter 18 of Law of Obligations, which talks about the duty of care, and I quote, subject to Articles 12, Subclause 2 and 3, a defendant owes a duty of care to a claimant where A. It is reasonably foreseeable that the defendant acts or omissions of acts could cause loss to a claimant. B. The relationship between the defendant and the claimant sufficiently proximate for the duty of care to exist. And C. It is fair, just, and reasonable in circumstances that the defendant would owe the claim of duty of care. A defendant who negligently creates a situation endangering life or property owes a duty of care to the claimant who suffers a loss as a direct result of attempting rescue, where it is reasonably foreseeable that that rescue could be attempted. Solar Team's negligence is failing to adequately
Sorry,
verify
Carlos. Sorry, Carlos. So to be clear, on which prong of the article or the law of obligations you're relying to? Which letter?
Article 17 talks about liability, and um, Article 18 talks about duty of care. And
Yeah,
subject to
I
these
know.
articles,
Yeah, I know. Well, I mean, which prong of Article 18? Is
subclause
it, yeah.
subclause 1 saying that it is reasonably foreseeable that the defendant's acts or omissions could cause loss to the claimant,
Okay,
and
so,
B,
so, so, yes,
sorry, Your Lordship,
yes. And B,
and B, the relationship between the defendant and the claimant is sufficiently proximate for duty of care to exist.
are these requirements cumulative or are they alternative?
They are cumulative as one leads to the other. Only when the claimant and defendant are proximate, the duty of care comes into existence. and that duty of care, when it comes into existence, has uh, that the standard of care included. The defendant owes that duty to the claimant.
Yeah, but when I say cumulative, I mean you need all of them. If any of them is missing, then there is no duty of care, or they are alternative in the sense that each one of them alone is sufficient to establish a duty of care.
These are alternative in nature.
So they're alternative, not
Yes.
cumulative.
Yes,
Okay.
Your Lordship.
And so which one is it?
Uh, Initially, the reasonable foreseeability and foresight.
Okay, so you're relying on the first prong. You're saying that the loss of your client was foreseeable.
Yes, Your Lordship.
Okay. Okay, and you will describe, of course, what that loss is. Okay.
Yes, Your Lordship.
Thank you. Go ahead.
So Solar Dream's negligence in failing to adequately verify Miss Asothia's medical condition before allowing her to board the spacecraft constitutes a breach of duty of care owed to its passengers. The duty of care in this context requires the Solar Dream to take reasonable steps to ensure the safety and well-being of passengers during the spaceflight experience. This duty encompasses conducting thorough medical assessments and screenings to identify any potential health risks that could compromise the safety of the passengers. Now, according to Chapter 17 of the Law of Obligations, a defendant is surplus 1. A defendant is liable in negligence to a claimant if and to the extent that the defendant owes a duty of care to the claimant. And focusing on that, the defendant's liability provided in Article 17(1) shall be reduced to the extent which the claimant's negligent acts or omissions contributed to his loss. So Solarim's failure to properly verify Miss Ashrathia's medical condition directly contributed to the foreseeable harm experienced by Miss Ashrathia and the other passengers. Had Solarim fulfilled his duty of care by conducting a comprehensive medical evaluation, it is reasonable to infer that Miss Asathia's COVID-19 infection could have been detected prior to boarding, thereby preventing the outbreak of the spacecraft aboard the spacecraft. As a result of Solarim's negligence, Miss Asathia suffered physical and emotional distress, including worsening symptoms of her chronic headaches during the spaceflight. Additionally, her loss of earnings as a YouTuber due to her inability to film the space yoga sessions, which was direct consequences of Solar Dream's actions, further underscores the extent of harm caused by negligence. Solar Dream's reliance solely on the lateral flow test amidst the prevalence of highly contagious
Sorry, can you
COVID-19.
stop you there? Can you stop you there, Cancel? So you're relying on the rule which says that if a party contributed to the causation of damages, um, that party should be liable for it, or at least should not.
It should.
Yeah.
Sorry, Your Lordship.
Can you expand a little bit on this?
Yes, Your Lordship. So, if a party contributes to the other party's harm, or in any way could have omitted an act that could have caused potential harm to the party, then they are liable for it. Liable for the damages they have caused.
Okay. And sorry, are you still talking about your client claim, or is this in relation to the counterclaim?
This is the claim.
This is the claim. Okay. And so who contributed to what?
Your Lordship, Solar Dream's failure to properly verify Miss Asathia's medical conditions contributed um, contributed directly to the foreseeable experience that she went through, which caused which could have been evaded by the comprehensive medical evaluation that they could have possibly done.
But if you're talking about contribution, usually this is a defense. This is a defense
But
for claim. So this might be relevant in relation to the counterclaim. Okay, so I understand, but of course it will be discussed in the second round. In relation to the counterclaim, I understand that Solar Dream has raised a counterclaim, and assume one of your defenses, one of your colleagues in your counsel will explain uh, why Solar Dream has contributed to those events and should be liable for it. But how is this relevant to your client's claim?
I understand, Your Lordship. The fact that Solar Dream owed a duty of care and contributed to the harm caused to Miss Asathia is what I'm trying to highlight upon.
Okay. Okay. Thank you. Okay. Thank you for this.
As a result of Solariteam's negligence, Miss Asuthia suffered physical and emotional distress. And given the pending PCR test results, which is known to be more reliable, the company neglected proper precautions for passengers for safety and evident from the cursory examination mentioned in paragraph 11 of the Moot problem. This hasty conduct reveals the company's prioritization of spaceflight and meteorological concerns over the essential COVID-19 testing. Moving on to inadequate response.
Sorry, Council. I did see the reference to meteorological concerns. What is the reference? What is the meteorological event that
Your
action is referring to?
I understand, Your Lordship. So, as the flight was to depart on the 15th of February, and for the departure of the spaceflight program, there were an estimates and an assumptions of meteorological conditions to find a proper time window for that particular spaceflight to launch into outer space, and that was prioritized over waiting for the PCR test result. Had the PCR test result had the company waited for the PCR test results, they would have lost the window of opportunity to launch into outer space.
Got it. Okay, thank you. Right.
Moving on to inadequate response protocols, in analyzing Solar Dream's conduct, it is pertinent to consider the precedent established in Fairchild versus Glenhaven Funeral Services Limited, 2002. In this case, the English House of Lords recognized that in situations where multiple factors contribute to the occurrence of harm, each contributing factor can be deemed a material cause if it significantly increases the risk of harm. Applying this principle to the present case, Solar Dream's negligent decision to proceed with the launch without waiting for the PCR test results materially increased the risk of harm to the passengers, including Miss Artemis Asathia. The causal link between Solar Dream's actions and resulting the harm suffered by Miss Asathia and the passengers is evident. Had Solar Dream implemented adequate response protocols and waited the PCR test results before proceeding with the launch, the risk of COVID-19 outbreak during the spaceflight could have been mitigated and prevented altogether. Therefore, Solar Team's negligence directly contributed to the harm experienced by Ms. Asothia and the other passengers. In addition, Clause 1.2 of the agreement states that parties shall work collaboratively to agree upon a suitable rescheduled date that accommodates both the spaceflight operator's operational requirements and the passenger's availability. The premature assumption of the passenger's health and false reassurance jeopardized their safety, particularly evident in Ms. Asothia's case while awaiting the results. If there are no other questions, Council seeks permission to proceed with the second leg of the argument.
Yeah, so you have around 3 minutes left. So I encourage you to address the entity of damage, the substance of the damages your client is claiming. In particular, whether all the damages claimed are foreseeable, whether they're direct or indirect. So I suggest that you spend the last 3 minutes on these points.
I understand, Your Lordship, but the second half of my argument deals with the breach of contract,
But
which is
I
a
think
part.
you already discussed, and I read the materials, I read the skeleton. I'm interested in um, in the quantum of damages and interested in the reasons why the client is claiming not only the direct damages, so the cost of the ticket and the time, but also I understand the client is also claiming direct damages. So I'd like you to address that.
Yes, Your Lordship. My client seeks damages and with the aspect of the tort being that they owed a duty of care, they failed to provide us with the duty of care, and 15 million in compensation for the economic loss that she faced as she was a space YouTube, as she was a yoga instructor and a YouTuber. So she would proceed to make videos in outer space and monetize them, and also the tickets that she had paid for. So these were the points of highlight for seeking the damage, for seeking the compensation.
Okay, and is your submission is that the essentially the profit that your clients will have achieved with with publishing the video had the trip continued, those profits are foreseeable, were foreseeable for the defendant.
Your Lordship, the harm that was caused to my client was foreseeable. The harm in terms of non-performance of the contract, as it was prematurely brought back to Earth.
Okay, and okay, but what is your client claiming?
We're claiming for compensation in terms of the loss that she suffered, both in the space type, its non-performance, and the duty of care that they performed,
And
and for
economically,
negligence. Yes,
how does this translate in numbers?
50 million.
50 million, and that represents, I assume, the cost of the ticket, the million,
Yes, Your Lordship.
right? And how do you justify the other 5 million?
The other 5 million in uh, bearing loss to her health, risk of harm to herself, the COVID-19 outbreak in outer space, her increased chronic illness,
Okay, so the 5 million represents compensation for what, medical expenses.
negligence, compensation for the negligence and harm that they caused.
Negligence is the legal ground, but I'm asking about what she's claiming for exactly.
She's claiming for the harm caused to her
How did the number of 5 million came up? How was that calculated? Based on what?
based on the harm that was caused to her health and emotional distress.
Okay, so that's emotional distress. Okay, got it.
Yeah.
Okay, I think Council, you're just finished your 17 minutes. I acknowledge they have been interrupting several times. Is there anything that you would like to add in 30 seconds?
Uh, no, Your Lordship. I would like to conclude my arguments. It was a pleasure arguing in this court.
Please.
So, in conclusion, by failing to mitigate the health risk effectively and ensuring the safety and suitability of the space retreat, Solardine breached the implied warranty of safety and suitability inherent contractual agreement, and Ms. Asothia reasonably expected the retreat to be conducted in a safe and suitable manner, and Solarine's negligence in addressing the COVID-19 outbreak directly contradicted this expectation.
Thank you, Council.
Thank you.
Okay, now I think we will hear from Senior Counsel for defendant Ms. Nair. Ms. Nair, when you're ready, you can address the court. You have 17
Right.
minutes, correct?
Right. Good afternoon, everyone. If it pleases the court, my name is Ishita Nair, and I am appearing as a senior counsel along with my co-counsel, Ms. Myra Khanna. Together, we represent the defendant, Solar Team Incorporation, in the present case. I will be taking 17 minutes of the court's time, reserving 5 minutes for the surrebuttals. Your Honor, I'm sure you are familiar with the facts. I would like to seek permission to move on to my contentions at hand.
Please.
In the present case, the defendant has two grounds. Firstly, that the defendant has not committed a contractual breach nor a tortious wrong and is not liable to pay 15 million US dollars. Secondly, that it is in fact the claimant who has committed a contractual breach and is liable to pay 5 million US dollars. This counterclaim will be dealt by my learned colleague, Ms. Myra Khanna. The council will be dealing with the first ground in the form of two prongs. Firstly, that there was no contractual breach, and secondly, that the defendant did not commit a tort. I will now be addressing my first contention that the defendant did not commit a contractual breach. I will be dealing with this in the form of three submissions. Firstly, that the non performance happened due to interference on part of the claimant. Secondly, that the principle of assumption of risk shall apply. And thirdly, that misrepresentation on part of the claimant acts as a defense to the claims of contractual breach. I will now be addressing my first contention. Your Honor, the claimant says that the defendant has committed a contractual breach by not fulfilling its contractual obligation of ensuring that the trip proceeded as planned. However, this is not valid due to her own actions that interfered with the defendant's contractual obligations. To quote Article 78 of the DIFC contract law, a party may not rely on the non performance of the other party to the extent that such non performance was caused by the first party's act. Your Honor, the claimant failed to disclose her chronic headaches during the medical evaluation and directly violated the mandate outlined in Article 5.2 of the Spaceflight Agreement. The same can be found on page number 14 of the Moot problem. To quote Article 5.2, the passenger declares, to the best of their knowledge and belief, that they are not aware of any medical conditions or symptoms of a potential medical condition that may affect their fitness to participate in the flight. Your Honor, by omitting this crucial information, the claimant hindered the defendant's ability to assess and mitigate any potential risk that was associated with her participation. Had the claimant disclosed her headaches, the defendant would have certainly waited for the PCR test results before proceeding with the trip. The defendant's contractual obligation to ensure the safety of the passengers and to ensure that the trip proceeded as planned was impeded by the claimant's failure to disclose her medical condition. Such an act deprived
Counsel,
the defendant.
sorry to interrupt you there. The what was the medical condition of the claimant at the time? What is the condition that she failed to disclose?
She failed to disclose that she was suffering from chronic headaches. And
Okay.
Your Honor, she failed to disclose this on three separate instances as well.
Mhm. And how is this related to COVID infection?
The symptom that she was suffering from, that is the headache, is listed as a part of the symptom that's there for the COVID-19 virus.
Okay, so your submission is that the fact that she had the headaches should have been an alarm that she
Indeed, Your
might
Honor.
have had it, even though she was already suffering of headaches for other reasons.
Indeed, Your Honor.
Okay, thank you. Go ahead, proceed.
Unless the court has any further questions for me, I will now address my second contention. The principle of assumption of risk absolves the defendant from any alleged liability. Assumption of risk is defined under Article 55 of the DIFC Law of Obligations. It states that a defendant shall not be liable if the claimant has knowingly subjected himself to the risk on which the claim is based. The same has been stated in Article 4 of the Spaceflight Agreement. By reading these provisions together, it is clear that the defendant cannot be held liable if the claimant knowingly subjects himself to the risk on which the claim is based. The claim in the present case that the defendant breached the contract by cancelling the trip is not valid, as the claimant, by signing the agreement, accepted the possibility of the trip being cancelled due to reasons beyond the defendant's control. Furthermore, Article 4.4 of the Spaceflight Agreement explicitly outlines the inherent risks of space travel, including unforeseen changes in mission plans.
So sorry,
Passengers,
for example, again, which article is it about the assumption of risk?
uh, it's Article 4 of the agreement and Article 55 of the DIFC Law of Obligations.
Uh-huh. Okay. Yes, proceed. And is there anything in the contract law?
Uh, I'm not aware of the same, Your Honor.
Okay, that's fine. Continue.
All of the passengers, including the claimant, were made aware of these risks, and she explicitly acknowledged them by signing the agreement. Therefore, by voluntarily participating in the trip and signing the agreement, the claimant accepted the potential risk that the trip might be cancelled for reasons which were beyond the defendant's control. Unless the bench has any further questions, I shall now address my third contention.
Yes, I do have a question. So Article 55 of the law of obligation says defendant is not liable if the claimant has knowingly subject himself to the risk which the claim is based. So what is the risk? How can you describe the risk in question? What is the risk to which Ms. Astroteia subjected herself?
Your Honor, the risk in question was the possibility of the flight being cancelled or rescheduled, which happened in the present case.
But the flight was not rescheduled. The flight was interrupted, right? They came back early, right? That's what happened. I think they flew for what, 3 days rather than a week.
I'm so sorry. Can you rephrase your question?
I mean, you said in this case the flight was not canceled because she boarded the flight, they they uh, they 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 flew away, and then once they were in the ship, then they found out that she had COVID, right? So the flight was not canceled, was it?
Your Honor, if you look at the facts of the case, the trip was cancelled. The same can be found on. Please give me a few seconds. The same can be found on page number 7 of the facts. The trip had
Mhm.
to be cancelled as all of the passengers had contracted COVID 19.
Yeah, but they were already there. They were already on the flight, or not?
They were,
They
Your
left
Honor.
the base. They left the
Right,
base.
but right.
So it
But
was
Miss
cancelled in the sense that it was terminated early.
uh, indeed, Your Honor.
Okay, and so the risk in this case is the risk that has happened if um, her infection will come up, they will have to go back
Indeed,
early.
Your Honor.
That's what, okay. And also during the flight, she couldn't do her videos. She couldn't really enjoy the trip because she was kept in isolation. Um, how was that foreseeable? How was it foreseeable that not disclosing her headache will result in this chain of events?
Your Honor, it is very important to note that the claimant did not disclose her headaches on 3 separate instances
Mhm.
because she was scared that she would not be allowed to go on the trip. This implies that she acknowledged that if she said that she had headaches, we might reconsider her ability to go on the trip.
So you said that she was no knowledge she was aware because she knew that she intentionally didn't disclose it
Indeed, Your Honor.
to avoid being excluded from the trip. Okay.
Indeed.
Okay. Thank you. You can continue.
I shall now address my third contention. Your Honor, the claimant's misrepresentation serves as a defense to the alleged contractual breach. My co-counsel will be elaborating further on how misrepresentation can be established in the present case, but I will be giving you a brief overview about the same. Failure to disclose information that induces the other party to enter into a contract constitutes misrepresentation. Article 29, subclause 5 of the DIFC law of obligation states that non-disclosure cannot amount to a representation unless the non-disclosure is a breach of a specific duty to disclose. In the present case, the claimant had a specific duty to disclose all of her medical conditions, which she did not, fearing that she would not be allowed to go for the trip. In the case of Atwood versus Small, the House of Lords held that false representation must form a material inducement to the formation of the contract, although it need not be the sole or the decisive factor. In the present case, the claimant failed to disclose her chronic headaches despite knowing its potential impact on her ability to participate. While this might not have been the sole factor for entering into the agreement, it undoubtedly constituted a material factor. Had the defendant been aware about her condition, they would have reconsidered her ability to participate. Moreover, common law principles state that the party against whom such a false representation is made can raise it as a defense to any contractual breach claims made by the first party. To conclude, the
Sorry,
misrepresentation.
sorry. Can you clarify this? So misrepresentation in principle is usually is the basis of a claim, but you're saying this can be also used as a defense. Okay, can you say again?
Indeed,
Was the authorities saying that?
uh, the authority for this is a book. It's called Anson's Law of Contract.
Ansels. law of contract. And you listed this in your authorities, right? In your index.
Indeed, Your Honor.
And it's on law of contract. Is this okay? Is this based on English law of contract?
Yes, Your Honor.
Okay, okay. Continue.
This brings me to the end of my first argument. To conclude, there was no contractual breach as the claimant's non performance, her voluntarily accepting the risk, and her misrepresentation act as a defense to any claims of an alleged contractual breach. I will now be addressing my second contention that the defendant did not commit a tort as it undertook all reasonable care and caution. Your
Counsel,
Honor,
since you have less than 4 minutes, can I ask you to include in this submission also some arguments about the quantum, what we discussed before with Mr. Siddhant regarding the quantum, regarding the 50 million, which one are direct losses, which one are not direct, how much of this was foreseeable for the client?
Your Honor, the uh, the the contention regarding the quantum will be dealt in the counterclaim. Um, but to to proceed with my contention, the the defendant cannot be held liable as it undertook a reasonable standard of care and caution. Your Honor, it is
Sorry, counsel. Why will this be addressed in the? This is relevant to the claimant's claim. What I'm asking you is, we discussed why that claim is not justified and why you submitted why your client has a valid defense. In the alternative, should one of those defense not be valid to exempt entirely your client liability, I'd like to hear from you whether your client should be liable for the whole 15 million or only part of that 50 million are recoverable by the claimant on the basis of the foreseeability or other legal theory explaining why only certain damages are recoverable.
Your Honor. Firstly, the defendant states that the that Miss Artemis has no legible ground to contend that she deserves a sort of a compensation.
Mhm.
However, if you look at the spaceflight agreement, it states that if there are any claims to be made, it cannot exceed $1 million. The same has been stated in the spaceflight agreement that was signed between the parties. And the claimant has no ground to contend that she deserves 15 million US dollars as compensation. The
Okay.
same has been stated in Article 4.5 of the spaceflight agreement that was signed between the parties.
Mhm. So you're relying on the limitation liability clause in the contract.
Indeed, Your Honor.
In in the
Indeed,
contract.
Your Honor. Yes.
In, okay. Yes.
If I may proceed?
Yes.
Your Honor, the defendant cannot be held liable as it undertook a reasonable standard of care and caution. In the present case, it is important to consider hindsight bias. The defendant's actions should be judged based on the information that was available to them at that time of the spaceflight. While the outcome may not completely align with the intended consequences, in hindsight, the defendant's actions were reasonable and sensible given the circumstances of that moment. As stated in Article 21 of the DIFC Law of Obligations, reasonable care is the care which a person of ordinary care and skill would have exercised. The defendant proceeded with the trip based on the advice of a medical practitioner, that is, the nurse on duty. The decision to rely on a lateral flow test instead of waiting for a PCR test was made only after considering the advice given by a medical professional. This was not taken lightly, but based on the assessment that a lateral flow test was sufficient statistically to rule out any serious risk that the passengers had COVID-19. This is also in accordance with Article 21. It is also important to note that the
Counsel,
defendant.
sorry to interrupt, but you just finished your 17 minutes. Would you like to take more time that will be taken off the from your colleague, or would you like to wrap up here?
I would just like 10 more seconds to conclude.
Okay, 10 seconds is fine. Yeah.
To conclude, the defendant's reliance on the advice of the nurse and its adherence to the standard procedure clearly shows that it took reasonable care and precaution in going ahead with the trip. To conclude, the council submits that there has been no contractual breach or a tortious wrong committed by the defendant. Now, my colleague Ms. Myra Khanna will be dealing with the second round after my survey buttons. Thank you so much for your time.
Thank you. So, carry on. So now we hear from the counterclaim, and we'll hear from junior defendant, correct? So we hear from Ms. Khanna, correct?
Your Honors, I suppose the order of pleading that the parties have agreed upon is to proceed with the rebuttals by the senior claimant, followed by the third rebuttals by my learned senior colleague.
No, sorry, there is rebuttal now. Apologies, my fault. Okay, so we have rebuttal from Mr. Kumar. Mr. Kumar, please.
Yes, Your Lordship. I've devised my rebuttals into three small parts. Firstly, I would like to highlight the part of knowingly subjected, which my fellow defendant counsel had stated. Uh, my client did not knowingly subject herself to COVID, and wasn't foreseeable, or it was foreseeable and could have been mitigated had the PCR test results been waited for. And secondly, the counsel stated that I'm sorry. The council stated that the tests conducted were reasonable and sensible, and also talked about ordinary care. Ordinary care is not justified for a space type program company, as they owe a higher standard of duty of care that a normal person would not owe, since they provide a very highly risky service. Thirdly, the PCR test results are not related to her headaches, since she had chronic headaches for the past 5 years, and it wasn't out of the norm for her, which did not make it essential for her to for her to depict during the final tests that were taken. Regardless of her chronic headaches, she still was infected with COVID-19, which the company was not able to detect in time. And when they did detect it, they was already in a situation that was worsened. Thank you.
Okay, and do you have anything to say about the limitation liability in the contract? You're claiming 15 million, right? But there is a clause saying that maximum liability is 1 million.
Your Lordship, we're claiming for negligence, and we want the particular claim quantified as we have previously quantified it for for the harm that was caused to my client in terms of emotional distress and increase in her chronic headaches.
Okay, and why? Okay, but why then? Are you saying that this clause is not relevant here? It's not applicable here.
Yes, Your Lordship.
Why?
As we're talking about a medical claim, and it doesn't state that any medical claims that we have in return have to be limited.
What does the clause say exactly? Can you get it?
Just a
Can you
second, Your
read it
Lordship.
for me? Can you read the clause for me, please?
Just a second.
Okay, it's page 12 of the record, paragraph 4.5, right?
Yes, Your Lordship. Which states
Uh,
that
In all
subject.
circumstances, the operator's liability for any and all claims shall be limited to a maximum of USD 1 million. It says any and all claims.
I understand, Your Lordship.
Okay, so what is your response to this?
We would still like to claim the 15 million for the damages caused to my
Yes,
client's health.
yes, but why this is not does not trigger this clause? This clause says 1 million, not 15.
Counsel, please ignorance.
Sorry, I rephrase the question. You're claiming 15 million. There is a clause here saying that any loss, damage, injury, expense of any kind, it's very, in my opinion, is a very broad wording. And it says whatever is claimed cannot be any more than 1 million. Can you explain me why you're submitting that your claim somehow your claim is not subject to this limitation?
Your Lordship, we've also claimed for the economic loss that we faced,
Uh-huh.
and also and amounting the economic loss, including the distress, the emotional distress that has been caused to her, and for the
Why is this not captured by this clause?
I plead ignorance, Your Lordship.
Sorry,
I plead ignorance.
you plead ignorance. Okay, okay. Then I think anything else for this rebuttal?
That's it, Your Lordship.
Okay, Miss Nair, shall rebuttal?
Your Honor, may I proceed with my rebuttals?
Yes.
Your Honor, the counsel states that the claimant knowingly subjected herself to the possibility of the trip being cancelled. She did this by signing the spaceflight agreement, and it was stated in Article 4.4 that the passenger understands and accepts the possibility of unforeseen events, including but not limited to changes in mission plans. Going ahead with my next contention, the opposing counsel stated that such headaches were not out of the norm for Ms. Artemis. However, the fact sheet states that just before the trip, she began suffering from very severe headaches, which clearly shows that there was a change in the status quo. The claimant knew that such headaches were a symptom of the COVID-19 virus. However, she did not disclose it. In fact, the fact that her headaches worsened even after signing the spaceflight agreement shows that this was out of the norm. To proceed with my next contention,
Sorry to interrupt you there. I mean, when we are dealing with the subject who has a pre-existing medical condition, right, that caused her headache. How are you saying that this headache was had such extraordinary intensity that it could not have been arising only by her chronic illness?
Your Honor, it is very important to look at the word severe, as the claimant had three separate instances to disclose that she had headaches. However, just a few days before the trip, she began to suffer from a very severe headache.
Mhm.
And in the months preceding the trip, it was public knowledge that the COVID-19 virus was on a rise. Knowing that her headaches might have been a symptom of the virus, she still did not disclose the same to us.
Okay.
If I may proceed with my next contention.
Yes, you have 2 minutes.
Your Honor, we were led to believe that the participants are physically fit because they did not disclose any medical symptoms. Because of this, we were not at a heightened risk of awareness due to the claimant's non disclosure. In hindsight, the claimant made the non disclosure on three separate instances. The claimant created an atmosphere of such a nature that we were made to believe that there were no reasons to be worried. Moreover, the PCR test was just one of the many medical tests that the defendant may conduct. Your Honor, such a test is not even mentioned in the contract. However, it was stated in the contract that the claimant must disclose all of her medical conditions, which she failed to do so. The defendant had absolutely no legal obligation to even conduct the PCR test, but there was a legal obligation on part of the claimant to mention that she was suffering from the headaches. Moreover, Your Honor, trips like these are of meticulous planning and are scheduled very precisely. Even an hour of I'm sorry, even an hour of delay may bring about unfavorable changes due to which the trip might not be possible. Your Honor, that brings me to the end of my rebuttals. Now my junior counsel will be taking over.
Thank you. Thank you, Ms. Nair. Ms. Khanna, when you're ready, you can address the court.
Uh, Thank you so much, Your Honor. The council seeks permission to collectively refer to the bench as your honor.
I'm sorry.
The council seeks permission to collectively refer to the bench as your honor.
To collect. Yeah, yeah, sure. Yes, granted.
Thank you and much obliged, Your Honor. Greetings, Your Honor. As my learned senior colleague, Ms. Nair has already argued extensively before this honorable court on how the defendant is not liable to the claimant for the breach of contract as well as the tort. If it may please the honorable court, I am Myra Khanna, and over the course of next 16 minutes, I shall be presenting the counterclaim before this honorable court. The fact of the case has already been rather expertly laid down before this honorable court. Therefore, I will be proceeding with my submission on the second ground that the claimant is liable to the defendant for a breach of contract. The honors are submitting this on two major grounds. Firstly, that the claimant had a duty to disclose her underlying medical condition as well as symptoms. And secondly, by failing to do so, claimant has breached the agreement, making the defendant entitled to damages. Proceeding with my first submission, Your Honor, we argue that the claimant had a duty to disclose her underlying medical condition. This has something been mentioned by my senior colleague as well, that such an obligation not only finds its place expressly under the agreement that the claimant herself had signed, but it was something in any case reasonably expected from her, as it was an implied obligation. Firstly, Your Honours, to establish how does an express obligation, if I may just directly went to this audit report, to page number 14 of the is the honorable court on page number 14.
Yes.
More specifically, Article 5.2 of the same, and to read with the very first line. Passenger declares and represents that, best to their knowledge and belief, that they are not aware of any medical condition or symptoms of a potential medical condition that may affect their fitness to participate in spaceflight. Your Honors, such disclosure of medical condition are absolutely necessary. Accurate medical examination, or even according to the United States recommended practices for human spaceflight occupants, people with certain medical conditions might be at higher risk during
Sorry, counsel. Why are the practices in the U.S. relevant here, considering that the flight departed from Dubai?
lead honor. For that, if we may just direct the attention of the court to the very next page, that would be page number 15, paragraph 7.2 of the same.
Okay, 15 paragraph.
Page number 15, paragraph 7.2, clause A. To read for the honorable court's convenience.
I'm sorry, page 15 of the record.
Of the record.
It's isn't it about severability?
Your Honors, it would be essentially paragraph 7.2 of the agreement, that is on reader.
7.2 of the agreement. Okay.
Apologies.
7 to the okay.
More specifically, clause A of the
US. Okay, latest version. Okay, thank you.
This is enforceable by virtue of this agreement, Your Honors, on both the parties. Now, according to these recommended practices, more specifically, the rationale underlying Article 3.4.3 of the same, people with certain medical conditions might be at a higher risk during space travel, as there are a lot of stresses associated with this. There are effects of microgravity, limited medical care capability available during space flight that could essentially worsen negatively.
Sorry, but one thing we have to add here, on the US policy. Yes, it is mentioned here, but it's mentioned in relation to the operator own conduct. So it says the operator undertakes to make efforts to ensure compliance with that. Why are you saying that also the client, the passenger should comply with that?
Your Honors, if I may just rephrase my earlier submission, our position isn't that the claimant has breached such recommended practices, Rather, our position is very simple. Claimant needed to disclose her underlying medical condition for the defendant to accurately comply with such regulated practices. Further, the counsel was simply stating the rationale that is given in these recommended practices for such disclosures, if
Okay.
that satisfies Your Honor's
Yes.
contention. In the present case, Your Honor, the claimant, as has been argued extensively before this court, suffering from chronic headaches should recently be disclosed by points it's important to mention. Exact cause of these headaches is not properly assessed or even diagnosed. Now, according to the WHO Atlas on Headache Disorders of 2011, the underlying reason could range anywhere from simple irritations to serious neurological infections. Accordingly, Your Honors, according to Your Honors, the State's tourism guidelines of Aerospace Medical Association headaches, if frequent or severe, serve as ground of immediate disqualification of a participant from space travel. Your Honors, the claimant in the present case knew of the possibility that and deliberately omitted to disclose her chronic headaches. And this is uncontested fact on record, Your Honors, that had she made a mention of her chronic headaches, the defendant may not allow her to board the flight. This, Your Honors, is a serious breach of Article 5.2. Now, further, the second line of Article 5.2 on page number 14 of the record reads, and to read for the Honorable Court, passenger further acknowledges the importance of providing accurate and complete information during medical evaluation. Your Honours, further, claimant was also given medical history law and was asked to list out all the ailments that she is currently suffering from or has previously suffered from. Your Honours, it's pertinent to mention, even on this occasion, that is the medical evaluation, the claimant again did not disclose her chronic headaches. Your Honours, it's not just these two omissions. On the same page, page number 14, Article 5.3 of the agreement again reads that passenger undertakes promptly inform the space flight operator if there is any change in their medical condition or if they become aware of any medical symptom that may affect their fitness for space travel. This includes any changes that occur between the time of initial medical evaluation and the scheduled launch date. Your Honours, to provide a brief context, weeks before the space flight, that is, the time between the initial medical evaluation and the scheduled launch date, as last line of Article 5.3 provides for, claimant again started to suffer from severe headaches. This was also accompanied with tiredness and fatigue. Your Honor, again, these changes in her medical condition were not informed to the defendant. This constitutes, and we argue, a breach of Article 5.3. In arguendo, Your Honor, even in a situation where the court does not consider or accept chronic headaches to be a medical condition under Article 5.2 or even Article 5.3 to be disclosed by the claimant, the position still is that at least the headaches constitute symptom of a medical condition needed to be disclosed by her. Your Honors, the medical condition now being referred to is the COVID-19 virus. This was again also mentioned by my senior counsel. Your Honors, to again provide a brief context, in the months preceding the spaceflight, there had been news of a new COVID-19 variant, 19, and its variant is a medical condition that disqualifies a participant from space travel. This would again be found in the United States Federal Aviation Administrative recommendation, more specifically Article 3.4 of the same, that provides for prevention of spread of any acute infectious disease during the spaceflight. In the light of this, in the morning of the spaceflight, each of the passengers were again examined by a nurse and were required to be tested for this virus. The headaches and the fatigue and the tiredness that the claimant had been suffering from, your honors was still not disclosed to the nurse. The reason for this was again that the claimant was afraid that the defendant would not allow her to board the flight. Honest, it's important to mention that the World Health Organization, in fact, had already declared not only headaches but also fatigue and tiredness as common symptoms of COVID-19 virus. They were, in any case, Your Honors, required to be disclosed by the claimant. Thus, our position is very simple, Your Honors. Headaches either qualify as a medical condition under Article 5.2 or 5.3 that were required by the claimant to be disclosed. And even in a situation where the court rejects this contention, our position is that at least they are a symptom of a medical condition, that would be COVID-19 virus, that were required by the claimant to be disclosed. Now, unless the court has any further questions and clarification on my first submission, I shall move on to the second link, that is, at least it was an implied obligation on the claimant to disclose her headings.
Counsel, since you have less than 7 minutes at this point, I think we already discussed the conduct of the claimant with your colleague, Ms. Nair. And I believe the grounds for your client's defense and the grounds for your client's counterclaim based on the are both based essentially on the conduct, or at least in part on the conduct of the claimant. But I'd like to hear more about the nature of your client's counterclaim, because this submission is about the counterclaim. So what is this counterclaim about? What are the legal grounds? Not the legal, not. We already discussed abundantly of what you say, Ms. Astrotaya should or should not have done. But I want to know why you say that the consequence of this is that your client has suffered a loss. What loss is that? And why is this recoverable?
Your Honors, if you could please rephrase the question. If
what is your client claiming?
Your Honors, my client is claiming $5 million in the form of compensation for firstly a breach of contract, secondly reputational damages, and thirdly the damage that was faced by the other participants because the trip has to be prematurely cancelled due to continuous of the claimant's actions.
Okay, do we know exactly how these 5 millions, how much of this 5 million are for breach of contract, how much are for reputation, and how much are for loss of income from other participants?
Your Honors, the exact breakdown of these numbers is not currently available because the facts are very much silent on the same. However, I can elucidate on these 3 points.
Yeah, okay, so breach of contract, I think we already heard about the breach of contract. The loss for cancellations, I guess, we don't have a direct cancellation, right? Are we talking about direct cancellations related to this particular flight, reimbursements for the participants to this particular flight, correct? Okay.
Yes, Your Honor.
I'm very interested in the claim for loss of reputation. Can you discuss that?
Indeed, Your Honors. The claim for reputational loss is again quite simple. The defendant is essentially alleging that the claimant's action, including publicly discussing the sequence of events and her pre-departure edits on her YouTube channel, led to significant reputational damages. There was widespread publicity surrounding the early cancellation of the flight, particularly in Dubai and globally, that resulted in multiple passengers cancelling their reservation for future space retreats. This loss of reputation directly impacts Solar Team's goodwill, business, and future revenue process. The information can be found on page number 8 of the report for the Honorable Court's convenience.
Sorry, what page?
Page number 8 of the Moot problem, Your Honor.
Number 8.
More specifically, para 15 of the same. In the very middle, the fifth line from above.
Yeah. Okay. And what is the legal ground? What legal principle of the DIFC law allows you to claim for loss of reputation?
Your Honor, even though there is no legal ground for loss of reputation, the DIFC law and the general principle underlying the same definitely do allow the defendant to go ahead for a loss of business and revenue.
Loss. Okay. Loss of revenue. Yes. And what is the legal ground? What is the legal principle? What is the right of action?
Your Honor, this in any case stems from Article 108, which provides for damages for a breach of contract. In any case, the underlying principle still provides the defendant for a leeway
One of
to
eight of the contract law.
plead your
One Article 108 of the DSC contract law.
to contract law, Your Honor.
Okay, so 108 of the contract law.
Apologies, Your Honor, that would be,
Sorry.
indeed, Your Honor, that would be 108 of the contract law.
Are you sure? Because it's 108 of the contract law is about protection of promisor from double liability. Are you sure you're referring to this article?
Your apologies, Your Honor, if I may just have a minute.
You have less than 2 minutes. So
Your Honor, I can provide you with the legal basis during my rebuttals if that is permissible.
well, okay, you will find the article, but can we at least discuss the legal principle? So is it loss of reputation per se recoverable under the DIFC law?
Yes, Your Honor. Even in a situation where the court rejects this contention, we still argue that damages in any case are still recoverable from breach of contract.
Okay, so breach of contract, okay. And why, and so your client is also claiming loss of profits, which are essentially indirect losses, right?
Perhaps,
They're
Your
not,
Honor.
they're not direct. The direct losses are the losses for this particular flight, right? For example, the people that cancel in the flight, those are direct losses because the flight was canceled. But the loss of profits is something that requires, an assessment of what would have happened, a but-for analysis, right? And what will happen had these events not occurred.
Uh, Indeed, Your Honor. If I may just have an extension of a minute to address a concern.
Yes, yes.
Uh, Indeed, Your Honor, that would be our position that in any case we are still seeking damages for a breach of contract. If that addresses Your Honor's contention.
Um, yes, okay. You have, I think, half a minute to wrap up your argument. You have 30 seconds to conclude your argument.
Thank you, Your Honor. As already argued before this court, the claimant had an express at least an implied obligation to disclose her underlying medical condition. The breach thereof entitles the defendant to damages. With that, unless the court has any further questions or clarification, the counsel rests its substantive arguments.
Thank you. I think we will now hear from Mr. Shipu, junior counsel for the claimant. When you're ready, you can start.
Your Lordship, may I begin?
Yes.
Greetings to Your Lordship. This is Junior Counsel Edwin, and I shall be dealing with the second issue. The second contention is concerning Miss Artemis's liability to Solar Dream for breach of contract. For the convenience of the court, the contention has been divided to two legs of arguments. Firstly, the fulfillment of duty of care. A duty can be an obligation upon a party, either in a general or specific sense. Most of the contractual relationships give rise to a specific duty of care for the parties involved. The fulfillment of these legal duties encompass as to whether the parties have completed their contractual obligation. In the current case, Ms. Artemis fulfilled her obligation by undergoing all required tests and medical examination as mandated by Solar Dream safety protocols. Additionally, she adhered to the quarantine measures after a flight from Montreal to Dubai. On 1st February 2024, she checked in the pre-departure accommodation provided by Solar Dream, that is the Dream House, and quarantined with the rest of the passengers for 2 weeks before the spaceflight. This exhibits her genuine commitment to following the safety protocols. Your Lordship can find this in paragraph 9 of the Moot problem. However, despite her compliance, an incident occurred that necessitated further evaluation. from the spaceflight operators, particularly in light of the emerging concerns about the new COVID-19 variant, the Vulcan. Incident as defined under the Regulation on Human Spaceflight Activities 2022 states that any unplanned event during pre-flight, flight, or post-landing that poses a high risk of causing serious or fatal injury to a spaceflight participant or a flight crew member. The spaceflight operators and medical team which were hired were well aware of the fact that this new variant was in the limelight, as evident from paragraph 11 of the Moot problem. The company clearly owed a duty of care to conduct a proper evaluation. Solar Dream owed a duty of care towards Miss Artemis. Article 18 Clause C of the Law of Obligations Act 2005 states that it is fair, just, and reasonable in the circumstances that the defendant should owe the claimant a duty of care, as mentioned by my co-counsel in his set of contentions. To justify the principle of duty of care, the counsel would like to take support of the case of Dongay versus Stevenson in 1932. If your lordship may refer to page number 33 of the Moot Court bundle, and I quote, "Whenever one person is by circumstances placed in such a situation with regard to another, that every one of ordinary sense who did think would at once recognize that if he did not use ordinary care and skill in his own conduct with regard to those circumstances, he would cause danger or injury to the person or the property of the other, a duty arises to use ordinary care and skill." Given the credentials of the medical professionals employed by Solargy, as stated in Clause 72, Subclause 5 of the Space Industry Regulations Act 2021, an approved aeromedical examiner means an individual who A. is qualified and holds a valid license to practice medicine from the General Medical Council, B. has qualification in aviation or space medicine, and C. which the Council would like to highlight, has been approved by the regulator for the purpose of carrying out medical assessments or medical examination for the purposes under this regulation. The failure to conduct a timely and accurate evaluation, particularly given the emerging threat of the Vulcan variant, can be construed as a breach of this duty of care. Clearly, it was the negligence of the medical examiner and the company in not promptly addressing the entire situation prior to the spaceflight launch. This highlights not only the incompetence of the medical examiner, but also the incompetence of the HR in hiring a proper medical team. Your Lordship, if you do not have any questions, may I move on to the second leg of my arguments?
Continue.
Okay, yes, Your Lordship. Moving on to the second leg of my arguments, that is the causal link to damages. One of the main constituents to establish liability is causation, as defined under Clause 10 of the Law of Obligations Act 2005. A claimant must show that, but for the defendant's conduct, he would have not suffered that loss, and that the defendant's conduct was a substantial cause of his loss. As per the agreement clause between Solar Dream and Miss Artemis, Clause 1.1 and 1.2 highlights that the launch window was contingent upon several factors, and it was not limited to the meteorological conditions. The virus breakout can be one of those adverse factors that is likely to affect the agreement. The failure to wait for the PCR test, the most authoritative examination in result to the COVID-19, constitutes a breach of contract. PCR testing or polymerase chain testing has emerged as a foundation in the global response to the COVID-19 pandemic. The importance and authoritative nature of the PCR test can be further exemplified by the fact that the UAE, Your Lordship, if you may refer to page number 41 of the Moot Code bundle, the UAE in 2020 had mandated COVID-19 tests for all inbound and transit passengers, including Emiratis, residents, and tourists arriving via the country's airports, irrespective of the countries they are coming from. Additionally, given that at the time, even PCR verification was mandatory for air travel as well. Your Lordship, to find this point, please refer to page number 40 of the Moot Code bundle. More than 90 countries require arriving air passengers to be in possession of a negative COVID-19 PCR result from a test taken within a prescribed number of days prior to arriving in that respective country. This disregard for this in the context of space travel demonstrates clear irresponsibility and a failure to fulfill due diligence as stipulated in the contract. Prior to the launch, the company neglected to exercise due care and hastened the procedure without adequate caution. This deviation from expected standard of care indicates a lack of responsible action on the part of the company as stated in paragraph 11 of the Moot problem, where it states that only a cursory medical examination was conducted by the nurse. Your Lordship, if I may go back to Article 55 of the Law of Obligations Act 2005, a defendant is not liable to a claimant if A. The claimant has knowingly subjected himself to the risk on which the claim is based, and B. The claimant wishes to subject himself to that risk, or agrees to subject himself to that risk. With regards to this, the Council would like to place reliance on the case of David versus Sykes in 1961, where the court in this case held that assumption of risk rests on two premises. Firstly, the nature and extent of risk are fully appreciated. Secondly, it is voluntarily occurred. Evidently, from the facts of the case, any damage that Solar Dream has incurred was clearly due to the COVID-19 breakout. Solar Dream voluntarily took the risk of sending the passengers to space, despite knowing about the delays in the PCR test results. They chose not to wait for the most authoritative test in this case, being the PCR test, making the decision to proceed.
Sorry, Counsel. Just to clarify, the risk that you say that Solar Dream has assumed is the risk of sending people to the ship while the PCR tests were not received. That's what you're saying.
Yes, Your Lordship.
But at the same time, also you mentioned UAE regulations regarding PCR tests. Were those regulations still in place at the time of the flight?
Sorry, Your Lordship.
You mentioned UAE regulations
Yes.
concerning testing. Were those regulations still in place at the time of the flight?
Your Lordship, the reason as to why the Council is stating about the PCR test being conducted in UAE is not the fact that it was being conducted at that time, but to show the authoritative nature of that test from the UAE government itself in having these kind of restrictions in place.
Yeah. So the test itself is authoritative. I accept that. But why will the COVID risk still be relevant when the flight took place after the end of the pandemic?
Your Lordship, because at the time a new variant was there, that was the Vulcan variant, which was known for its increased transmission rate. And and it was not like the Solar Dream company did not want to conduct the PCR test. They did conduct the PCR test, knowing its significance. It was because of the delay in the labs that resulted in them sending the passengers to space.
Okay, thank you. You can continue.
Lordship, I can continue.
Yes.
Pursuant to this, the Council would like to state Clause 72, Subclause 1, and Clause 73, Subclause 1 in the Space Industry Regulations Act 2021. Clause 72 states that the licensee must ensure that, and the Council would like to highlight subsection C in this, no person takes part in spaceflight activities, either as a crew member or a spaceflight participant, if that person is not medically fit to fly. Furthermore, under subsection 2, it states that the procedure established by the licensee to ensure that it satisfies its obligations under this paragraph, and the Council would like to highlight point A in this, medical examination and medical assessments were to be conducted by an approved aeromedical examiner. In, in conjunction to this, under clause 73 subclause 1, no individual may take part in any spaceflight activities unless that individual, and the Council would like to highlight point B under this, in the case of a spaceflight participant, has been confirmed as being medically fit to fly by an approved aeromedical examiner. Solar Dream had given the permission for takeoff as the company.
Sorry to interrupt you again. You're saying is that the defendant assumed the risk that there will be problems because they didn't ascertain that Miss Astrateia was fit to fly. But at the same time, Miss Astrateia had a hint that she was probably not fit to fly as she was suffering for those head itches before the flight. So hasn't she also assumed the risk of the flight? Hasn't she accepted the possibility of being liable towards the defendant for the failure to disclose a
Your
condition.
Lordship, Your Lordship, her suppression of the fact that she had chronic headaches is not material in nature. In order for a fact to be material in nature, it must be of substantial value to the company. Here, as the council is highlighting, any loss that Solar Dream has incurred was clearly due to the poor safety protocols in place and not due to the medical condition of Miss Artemis, that is her suffering from her chronic headaches.
Okay.
Your Lordship, may I continue?
Yes.
Okay, Solar Dream had given the permission for takeoff, as the company felt that the lateral flow test was sufficiently statistical to rule out the possibility of COVID-19, as mentioned in paragraph 12 of the Moot problem. Furthermore, it is evident that it was the Solar Dream personnel who had decided to give the green light for takeoff. Referring back to the case of Donaghy versus Stevenson in 1932, the court stated that the cardinal principle of liability is that the party complained of should owe to the party complaining a duty to the care, and that the party complaining should be able to prove that he has suffered damages in consequence of a breach of that duty. Your Lordship may find this under page 38 of the Moot Court bundle. As Miss Artemis's PCR test came back as positive, the company now is clearly trying to shift the responsibility to the client as it resulted in huge damages to them. Solar Dream has failed to show any substantial evidence to further the point that Miss Artemis is liable for the damages caused to the company. Furthermore, the causal link to damages is not in conjunction with the chronic headaches but the poor safety protocols in place by the company. Thus, the onus of loss suffered by Solar Dream cannot be attributed to the client's medical condition. That concludes my set of arguments. If your Lordship does not have any questions, I, I can conclude.
No, no, you can correct.
Your Lordship, I can conclude.
If you still have 3 minutes, I believe, but up to you if you wish to, if you're done with your argument, if you wish to
Yes, Your
finish
Lordship.
further, up to you.
I'd like to conclude in 30 seconds.
Okay.
The Council seeks for the dismissal of the counterclaim, holding Miss Artemis Historia liable for the breach of contract. It was a
Okay.
pleasure arguing before this honorable court.
Thank you. Rebuttal, Ms. Khanna,
May I proceed?
please.
Your before that, regarding damages, apologies for the initial oversight. Essentially, Section Article 109 and not 108 the DIFC contract, which provides for a remedy to seek damages for non-performance. Your Honor, it's also particularly mentioned non-performance here can not only amount to breach of Article 5.2 and 5.3, but also any irregular or failure to perform any of the obligations in the appropriate manner. Thus, erroneous performance also
So to be
contributes
clear, you're relying on 109 of the contract law.
indeed yours.
How about 110 and 111?
Your Honor, for the computation of damages.
In relation, I mean, I'm interested in the loss of reputation in particular. So what 109 says is that a party is entitled to claim damages in the general statement. Now, 110 says that a great party is entitled to full compensation, and that includes any loss as well as any gain to which he was deprived. And then 111 says that the loss must be measured by the loss of the party performance and the loss. So, anyways, so I'm interested in 111. Do you think, sorry, 110. Do you think 110 is applicable here?
Insofar computation of damages is concerned, the Council presently believes that 111B, which provides that any loss, including incident consequential loss caused by the breach, would be more appropriate.
Okay, so the loss of reputation claim, where does it fall? In this, for example, in 110, the way 110 describes losses, how is your loss of reputation claim justified on the basis of the language of 110?
To be honest, to reiterate, presently, we still believe that falls squarely within 111B. The Council pleads ignorance insofar the applicability of 110 is concerned.
Okay, thank you. I think you still have a couple of minutes for your rebuttal.
Thank you, Honest. It is, as my learned friend on the opposing side has pointed, that when Artemis disclosed her headaches, our client should have still ideally proceeded with the COVID-19 testing. However, it's further to mention, Your Honor, that PCR tests, in case, was done for individuals who are likely to be symptomatic of this virus. Our client went ahead with just the PCR test and did not wait for the results, squarely because of the representation of the claimant's client that recently led the defendant to believe that they could, in fact, go ahead with the test. Your Honor, had she simply done so, as my senior counsel also highlighted, my client would have been in a heightened list of awareness and would not have gone ahead without waiting for the results of the test. In any case, this even if court considers this to be, uh, we argue that the direct causal link is still not established between the alleged failure of performance of my client and the claimant's non-performance. Moreover, we argue that an obligation to disclose symptoms does not only find an explicit mention in the agreement, and unlike the defendant's alleged breach, uh, there is there is a direct, at least an indirect causal link to damages. With that, given that I am functioning under certain paucity of time, I conclude my remarks.
Sorry, what do you say? You concluded?
Indeed, Your Honor, I conclude my submission.
Okay, thank you. Thank you, Ms. Khanna. I think now we have short rebuttal from Mr. Shibu.
Your Lordship, the learned counsel had mentioned that the headache is a symptom of COVID-19, but Artemis has been suffering from these chronic headaches for the past 5 years. And furthermore, when the headaches had worsened, this was also not something that was uncommon for her. So the claim that she's symptomatic of COVID-19 is false. Furthermore, the council feels that the causal link to damages has been clearly stated by the council. Here, the council has mentioned that it was clearly due to the poor safety protocols and the duty of care which was owed towards Ms. Artemis was not owed. And furthermore, the negligence from the company in in not waiting for the PCR test is the true reason as to why Solar Dream had suffered the losses.
Okay.
Your Lordship, I'd like to raise one more point.
Yeah.
The learned counsel had mentioned that they're seeking damages for defamation or slander. But clearly, in the last paragraph of the moot problem, it is stated that the damages they're seeking is not for defamation or slander, but it is a claim totally based on the breach of contract. Your Lordship,
That concludes your argument?
Yes, Your Lordship.
Thank you. Okay, I believe that concludes this hearing. It's 1:36 p.m. We are more or less in time, and thank both parties for being adherent with their time allocation. And I think that concludes the hearing. So normally there will be some deliberation, but since I have nobody to deliberate with, I will provide you my feedback directly. Is everybody here? Ms. Nair, Ms. Khanna? Okay, very well. So let's start. First, general clarification. There's also your skeletons. I encourage. I mean, now they're submitted, but if you ever do this exercise again, I encourage both of you to read very carefully the instructions for preparing the bundle. None of you paginated the bundle. Paginated means that you, for example, the defendant bundle, I think, is runs around 40 pages, I think. So I would have expected that you paginate the bundle means on each page you put numbers on each page. So on each page I will see the number of the document. So for example, your skeleton will have its numbering, but I also would like to see on the skeleton where in the bundle that falls. This is important. If you ever do this professionally, courts and tribunals expect to see that. So remember to paginate the bundle. Second question, also another thing I think I noticed in the defendant bundle also is that you included authorities. Yeah, actually, yeah, you included authorities. Okay. Include also. Make sure you include also the cover. So if you include or the first page. So if you have, for example, you quoted here something, I believe, Donog versus Stevenson. I think this is taken from a book, I think. I don't know from what book this is from. So add also the cover. So for example, in your bundle, right, there is a page which is quoting George versus Skivington, where there was an injury, blah, 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 the person, the wife, etc. This is an extract, it's page 571, 72. Okay, there is an excerpt starting page 571. Make sure to include also the cover. So if this is from a book, include also the cover of the book. Otherwise, it's difficult to understand where this excerpt is coming from. As a general remark on the and question for the claimant on your bundle. I received the skeleton and I received the index. And I received the index. Have you also included in your bundle the actual authorities? Have you included any materials in your bundle? Claimant, this will be for Siddharth and
Yes,
for
yes, we have
Edwin.
your lordship.
Okay, because there might be a problem then. It might be, don't know if anybody from admin is here.
Yes, Rodrigo.
So from one of the participants, and I believe it was defendant actually. Sorry, well, I think it was what was it discussing. I think it was about the claimant, not about the defendant, about the case and the cover page missing. So for one of the parties, and actually that applies also to the second round I have in 1 hour. I only received the skeleton, but not the authorities. Sorry, I think I was wrong. It was actually that's the case for the defendant bundle. So the defendant bundle, Shira and Mira, there's only the skeleton here. You have not produced the authorities, right? Yeah. Okay. Well, for you to know, this exercise was also about including the authorities. Okay. And sorry. So then the comment I had about the article, sorry, was for you, Siddharth and Edwin. So there is I think you quoted an excerpt of a book, but the cover is missing. So it's difficult to understand where this excerpt is coming from. Whenever you include authorities, if it's a long authority, there are many pages, you do it right that you only copy the right passage, but always also page number 1, so I know where this is coming from. Okay. Now regarding this hearing, we'll start from Siddharth. And I think it's not just you, but also the other participants. So like all cases are about liability and quantum, right? So here both parties have a claim and have to defend against the claim from the other side. Okay. So the first level here is to say, we didn't do anything wrong, or the other side is so wrong that we have no liability, or on the other hand, the other side is so wrong that they should pay everything. Okay, that's liability. All of you have addressed liability, and I think there is some overlap. But I think this is the way the problem is designed. There's a bit of overlap between senior and junior counsel in the sense that both of you address liability. But remember the quantification of damages. So the question I have for you about the limitation on liability, you cannot plead ignorance. You cannot. It's very important. You need to have an answer to that. And that's only one of the elements, because you need to tell me why this clause doesn't apply. Why? Otherwise, you're already limiting your claim. You only have 1 million claim, not a 15 million claim. So you should have a valid response. This is important. And also, your Astroteia is claiming damages for basically the 10 million, which is understandable, the flight cost. But also the other 5 million, you need to frame a damages theory, right? So is this compensation? Compensation for what? Compensation for the clicks and the money she will make on YouTube, on Instagram, whatever, publishing her story. You need to describe it. Purposefully, the Moot problem doesn't say much about that, because they want you to describe it, and also you need to have the law very, very clear. So there are limitations in this contract as to what can be claimed, and also limitations in the law as to what can be claimed. And finally, last thing is a general matter of this is about the substance. It's about there's some more preparation to be done, but as a general rules of presenting an argument, always make sure you always refer to the record. You haven't done that much. Refer to the record, and also refer to your skeleton. You should say at this point, as we say, a paragraph whatever of my skeleton. This is our submission. This is what we're saying. Okay, but well done. And then Ishita, you were the second person speaking, so you already heard Siddharth. So you have the great, at the same advantage and challenge to have the opportunity to respond. So your intervention is basically a very long rebuttal. Of course, you need to plead your position, you need to plead your case, and it's always a good idea at the beginning of your argument, as you did, to state what your case is, what is your story. But the process in a common law court like this one is really an adversarial process. So as long as you're defending, because you're pleading the defense, not the counterclaim, your main goal is to destroy what Siddharth said, to reply to each and everything that he said. You didn't do this that much. You kind of went on your own way. Of course, you prepared your submission, but you missed the opportunity to respond to what Siddharth said. Usually, that's what courts find helpful. Usually, courts, commercial courts, usually the judges are very hardworking, very specialized. They read the record. They come to know the case very well. They want to, in the presentation, they want the parties to fill the gaps. And so, to the extent that Siddharth made some new arguments or provide some new background, you have the opportunity to reply to that. Okay, so keep that in mind. Then we have Mira. Mira, something both for you and Edwin. So this second part is about the counterclaim. There is no need for you to repeat the same thing that the senior counsel said about liability, what the other side was wrong, what you did right. This should be more for the first part. This is a case where, on the basis of the same conduct, you're defending against the other side claim and you are asserting your counterclaim claim. So if one party misbehaved, this is relevant for both the claim and the counterclaim. But the party misbehaved in principle. I already heard about that for over half an hour from your colleagues. So there is, I think you should use you should make a better use of your time talking about the damages themselves, and in particular, and you see, I insisted on the loss of reputation because it's the most difficult claim. The direct. So first of all, you should ideally frame clearly as a matter of law what your losses are and how and why those are actionable, recoverable losses under the law, right? So you should state ideally that um, some of them are direct losses, other indirect losses. So, for example, the value of ticket and the value of the tickets of people that canceled, those are direct losses and are pretty straightforward. If you are successful in liability, if the court determines that Astrateia misbehaved, misrepresented, whatever, then it's pretty straightforward that the direct loss arising from that particular flight should follow. So it's sufficient just to mention legally how that works, but not necessary to spend a lot of time on this. But then the loss of reputation, that's a difficult claim, and I insisted on that. I have a case right now here in the DIFC, which is exactly about that. It's a dispute between company and the former executive. The company says that the employee misbehaved, and because he misbehaved, he damaged their reputation, and nobody gives them any more work, and they destroy their reputation in the market. So it's very similar ground. This is a very, very difficult claim to make because under in this country, everything that is about reputation, conduct, defamation, libel, or slander would be in another jurisdiction. It doesn't exist in the DIFC. It doesn't exist because this is something which is relevant by a criminal standpoint before the local Arabic-speaking courts. In the DIFC court, you cannot make a claim for libel or for slander or for loss of reputation per se. So the only way, and you said that, is to frame it as a claim for loss of profits. But it's still a difficult claim. What profits? How do you describe those profits? What evidence have you provided of what these lost profits are, and why are those recoverable in contract or under the law obligations? So think about this, and I think you should spend a little bit more time if you ever have this role again on that point. And I've been again similar, I think, remarks for you. First of all, you should be replying to what Mira said. You've done that a little bit, but not that much. I think your intervention was mostly about taking point by point and disassembling point by point what Mira said and responding to what Mira said. And you haven't done that much. You refer to the record, which actually also Mira, you refer to the record. You did this very well, both of you. But I haven't heard a lot from you about the legal grounds, in particular I would have expected to hear from you rather than on the conduct of what the parties did or did not do right, where they misbehaved, whether in fact their conduct was right or wrong. I like to hear more about why that conduct does not follow into a claim by the defendant, why there are no legal grounds for that claim, why that even if your client conduct was wrong, still the defendant has no claim. I would expect to hear a little bit more about that. And finally, a remark for everyone, the rebuttal and short rebuttal. By nature, rebuttal, short rebuttal, should be brief, short, and on point. I think some of you spend the whole 5 minutes, or even ask for more than 5 minutes. For an effective rebuttal, 1.5 minutes is sufficient. Just take again the points from the other side, take those points in one brief word, sweet and simple, why that what the other side said is wrong, and why your client should prevail. So I encourage you to allocate a bit more time on the main argument and to be more impactful and brief on rebuttal and short rebuttal. And I think that's all for me. You have any questions?
Just one question. So the counterclaim essentially just stated that that the claimant is liable to the defendant for a breach of contract. So I personally interpreted this as going into the legalities of the case and looking at whether or not the claimant has breached the contract. Uh, the computation of damages essentially did become a difficult question, even if the record just states that the defendant is asking million US dollars. When I personally read it, I was not able to exactly break down the numbers as to why and how they arrived at the figures. So I just want to ask how exactly or what exactly do you expect me to go about it? What would be an ideal rate when the record is like very much silent of this?
Well, I mean, I think I asked about the breakdown. You might not have an exact breakdown. That's fine, but at least explain what are the components. And even even if it's not on the record, the breakdown, just try to think what could the breakdown could be. So the claim is 5 million, right? 5 million, right? So try to think about what that breakdown could be. You could say this is represented by profits lost from tickets from cancellations and for potential new tickets that could have been bought, but they were not bought. Just think about something reasonable.
All right, that makes sense. Thank you so much.
Thank you. Okay, I think that's all from me. Thank you very much. I'm glad to see you presenting, and I wish you the very best in this competition and for your future.
Thank you.
Thank you so much.
Thank you, sir.
Thank you, everyone.